Hi everyone, my name is Ruth Floren. I have completed my master's degree in forensic psychology from National Forensic Sciences University, India. Now, I'm going to talk the major areas of forensic psychology. Examining the major areas of forensic psychology and law itself is one way to gain a better understanding of forensic psychology. Forensic psychology is typically divided into criminal and civil aspects. This division of forensic psychology roles and tasks is based on the legal distinction between civil and criminal law. Criminal law Now, let's talk about criminal law. Criminal law focuses on acts against society. The government is in charge of prosecuting criminal cases through law enforcement officers and prosecutors. The goal of criminal law is to punish offenders in order to maintain a sense of justice in society and to deter crime. The murder that may have occurred last night or the mugging down the street are considered criminal law violations because we, as a society, do not consider these behaviors appropriate and consider violations of criminal law to be an offense against any of us. When the state or government believes an individual has violated criminal law, it acts as the prosecutor on behalf of society and files criminal charges against defendant. There are a number of criminal law specific legal issues frequently play a role in the practice of forensic psychology. Mens rea. Mens rea, for example, is a criminal responsibility principle relating to an individual's mental state. Mens rea, or guilty mind, refers to an individual's willful or intentional commission of an unlawful act. It implies a defendant's culpability or blameworthiness. Although psychologists are not called upon in every criminal case to render an opinion on whether a defendant had a guilty mind, they are called upon in certain circumstances. These instances usually focus on the issue of insanity. In insanity cases, it is the responsibility of the forensic psychologist to assist the court in identifying whether a defendant suffered from a mental illness and if it prohibited him from forming mens rea and therefore committing the crime intentionally. Other relevant instances in criminal law may include when a juvenile or mentally retarded person is facing the death penalty. Supreme Court cases have ruled the offenders under the age of 18, Simpsons 2005, and defendants suffering from mental retardation, Virginia 2002, do not have sufficient mental capabilities to form mens rea and are not legally responsible for capital offense. Therefore, they cannot be executed. So now, can you see the role of forensic psychology in criminal law? Then, second is civil law. Is, a, is concerned with private rights and remedies rather than public good. If I cause a car accident because I'm driving too fast and hit another person, I can be held civilly liable because I have caused harm to that person. Torts are a type of civil law that involves a wrongful act that causes that causes harm to another person. Furthermore, it is up to the victim, not society to take action. For a third to have occurred in the car accident above that I told before, I must have owed a duty. Generally, it is legally recognized that operators of motor vehicles have a duty or a responsibility not to collide with other drivers or more generally to obey traffic regulations. For example, I have a responsibility or duty to turn left only when there is a green light and no oncoming traffic. If I collided with another driver because I turned left while a traffic light was red, I have violated or breached the duty. Or a breach of duty can be intentionally or a result of negligence. Negligence occurs when an individual falls below an ordinary or responsible level of care. So even if I did not intend to turn when the light was red, it may have been negligent of me to do so because a reasonable person would not have turned at the time. Civil law generally recognizes that there must be damage because one of the purposes of civil law is to compensate the victim for damage suffered and even to restore him to his prior state, whether that is physically, psychologically, or financially. In civil law, one party, the plaintiff, must bring action against someone who has violated his rights, the defendant. In the above example that I already explained, assume that my insurance company and I refuse to compensate the person for any damage he suffered. The plaintiff, the person I hit with my car, must file lawsuit against me and urge that I caused the car accident that resulted in his injuries. In this instance, a forensic psychologist might evaluate the plaintiff to see if he has suffered any psychological damage as a result of the accident. For the example, the plaintiff may suffer from post-traumatic stress disorder or PTSD and be afraid to drive or experience significant anxiety when he drives. The plaintiff could ask to be compensated for his emotional trauma and for the cost of any psychological assistance he sought out. To take a break from this topic, we can distinguish example areas of forensic practice in criminal and civil law. In criminal law, first is risk assessment at the time of sentencing. Second, insanity and criminal responsibility. Third, competency to stand trial. Fourth, treatment of sexual offenders. And fifth, juvenile transfer to adult court. However, the area of civil law is first, child custody, second, civil commitment, third, personal injury, fourth, workers' compensation, fifth, competency to make medical decisions. So this is the end of my introduction to forensic psychology topic. I hope you have a good understanding of forensic psychology. And in the next videos, I'll go into greater detail about forensic psychology. All of my materials come came from Matthew T. Huss in 2014 book on forensic psychology. I promise to declare the truth. Bye bye.